Good morning. I'm Paul Truster, Director of Continuing Legal Education for the Law Society, and I'd like to welcome you to today's program, Suing or Defending Professionals, which will begin in just one moment. I do want to draw your attention just briefly to the course evaluation form, the gray form which lies a few pages into the materials. We take these very seriously. We read each one. They guide us in planning programming that will best meet your practice needs. So you would be doing us a great favor, but also acting in your own self-interest if you could complete it by the end of the day and leave it at the registration desk outside. And if for any reason that's impossible, please do fax or mail it in. Is this microphone carrying to the back? It is. Good. The materials, as you have them, are basically complete. There was a briefing book prepared for use of the faculty, which I've become acquainted with over the last couple of days, and I think what we're going to do is to pare it down only slightly, reproduce it, and mail it to each of you after the fact, and so that will supplement the materials you have, which are certainly not intellectually slender, but physically somewhat slender. I will also take a moment with great pleasure to thank all the faculty who have prepared the materials that you have before you and the presentations that you'll be hearing today. We're very grateful to all of them. I don't recall an occasion where we've had a more distinguished faculty, and we're very proud of them and the work that they have done. Without discriminating among them, I feel I have to make some special mention of Sandra Secord of Torque and Mains, sitting in the third row here, and Stephen Grant sitting in the first row, because apart from serving on the faculty, they have done a great deal of work with the chairs in planning the program, and indeed it wouldn't be inappropriate to think of the four of them as in effect the planning committee for the program. Our two chairs sitting to my left are Gavin MacKenzie, closest to me, well known to you, I'm sure, of Janae Murray, a bencher and author, and Milt Davis to his immediate left of Bresver, Grossman, Scheiniger, and Davis, who asked to be introduced as a well-known sewer of lawyers and other professionals. I understand that Gavin will speak first, and I ask you to join me in welcoming him. Thanks very much.
Well, thank you, Paul. I certainly don't expect to be very long. I did want to thank the people who have agreed to speak here today. We really are proud of the quality of the people we've been able to induce to come to speak to a continuing education program on December the 15th. We're also pleased at not only the number of registrants that are here today, but the number of very experienced senior counsel involved in the type of work that we're going to be talking about all day. I think that's certainly going to make for a lively discussion as well when we have question periods after speeches and panels. I'd like to introduce our keynote speaker, and we don't propose to spend a lot of time on introductions today because everybody here knows how to read a CV, but we're particularly pleased the Honorable George Adams has agreed to be our keynote speaker. George has had more successful careers than any three people that I know. He's a former law professor, a former senior civil servant, former chair of the Ontario Labour Relations Board, the author of Canada's leading text on labour law, for which he won the Walter Owen Book Award, a former litigation partner at Castles Brock, a former labour management side labour lawyer at Fasken Campbell Godfrey, not to mention a former Superior Court judge and currently a leading ADR practitioner. So thank you for joining us, George.
Mr. Justice Goudge says I'm a walking definition of a has-been. I think there's a lot of truth to that. I'm honored to be asked to talk to you today, particularly as the front end of such a distinguished group of presenters. I think we're all privileged by these people finding time to share their experiences and their views. I've been asked to address the topic, where are we and where are we going? This is a topic addressed to me, I think, by Milt for lack of time to craft a better, more precise question. And so Milt has given me this burden. And I'm reminded of a story of Mr. Justice Holmes when he was quite old and traveling by rail, and he got on a train, and a conductor overcame him, and he was searching through his pockets, and he was immediately recognized because he was, of course, famous, and the conductor said to him, Justice Holmes, don't worry about your tickets. When you get to wherever you get, you'll obviously find them, and then just send them to the company. And Holmes kept searching through his attire, and then finally looked up and said, young man, and the conductor was about 75, he said, young man, the problem is not where are my tickets. The problem is where am I going? And I think we'll have that problem at the end of the day. I think we'll still have that problem at the end of the day. And fortunately, there are people much more qualified than I that are going to speak to and point us all in the appropriate direction. They're really carrying the burden, not me. This topic, suing and defending professionals, gives me the jitters. Unless one spends his or her life removed as a legal academic or a judge, a reading of the case law in this field cannot help but produce anxiety, if not profound empathy, whether you are a practitioner or a potential client. The legal obligations of professionals are complex, extensive, and I would submit very uncertain. The potential for infinite liability is increasingly present. The related opportunity for litigation has swelled with the 20th century rise in professional classes and the absence of meaningful self-governing institutions associated with this new elite. A global economy, the related trend toward the provision of services in contrast to manufactured products, and the increasing sophistication of the provision of those services due to technological and educational changes have all contributed to the multiplicity of well-paid jobs occupied by professionals now hawking their services on the internet. The historic professional callings of doctor, lawyer, clergy have been joined by multitudinous others, and everyone seems to have a marketing plan and a brochure. The legal obligations of the historic or common callings have always been interesting. They predate the very existence of modern laws of contract and tort. Therefore, their own early legal framework had to be reconciled with and integrated into the laws of contract, tort, unjust enrichment, and fiduciary duty over the years. That's what makes the cases so stimulating, say the academics. Limitation cases in this field sometimes reflect on this rich and venerable history. The stakes in litigation against professionals are usually large. The essence of a professional's capital is his or her name. Proven incompetence can spell the end to that person's career. Fellow professionals who are also competitors and expert witnesses can be particularly heartless in taking advantage of such professional plight. Rising claims of expertise and professionalism, however, are increasingly used to snare the vulnerable client and access his or her resources with sometimes tragic effects. This is why litigation involving professionals is usually hard-fought and too often culminates in a trial. The very nature of professional work puts these persons in the midst of important matters like complex commercial transactions, such as construction projects, surgical operations and other medical interventions, financial planning, a variety of profound personal decisions, and important monitoring and custodial roles. Any failure in performance by the professionals can produce or contribute to massive harm suffered by others, harm that may far exceed the compensation being paid for those professional services. This reality raises the specter of ruinous financial consequences for the client, for the professional who is sued, and for his or her partners because of the law of joint and several liability. With professional liability comes the need for liability insurance and the increasingly prohibitive cost of obtaining it. As Cardoza CG explained in Ultramares Corp and Touche years ago, liability in an indeterminate amount for an indeterminate time to an indeterminate class became ever present on the advent of negligent misrepresentation, a too prevalent modus operandi for professional liability. This in turn has created much uncertainty as the courts have struggled in the professional context with the two-part test in Annes v. Merton London Borough Council and is adopted in Canada in Kamloops v. Nelson. What is the scope of the professional's duty, and are there any considerations which ought to limit the scope of the duty, the class of the person to whom it is owed, or the damages to which a breach of it may give rise? Auditors' written opinions have been particularly vexing in this regard, as illustrated by the Supreme Court of Canada's decision in Hercules Management, Ltd., and Ernst & Young. Professionals, by virtue of their importance to clients, attract more than tort and contractual obligations. They are often described as fiduciaries, and the law of fiduciaries is replete with a range of demanding but very general obligations centering on the utmost good faith. This perspective can increase the stakes, the duty, and the legal uncertainty as those injured take professionals to court to complain about the disastrous consequences of their actions with the 20/20 vision of hindsight. The recent Martin v. Ferrano Green case is a case in point, possibly. That case may also illustrate the potent effect of business friendships in muting professional duty. In this context, the sympathy may not lie with the well-paid professional and his or her magnet of professional indemnity insurance. The HIV blood cases demonstrate the capacity for malpractice cases to attack the very underpinning of particular institutional settings and the need for whole professions to keep pace with technological change and societal trends. Litigation against professionals can also have grave licensure implications for the member of a self-governing profession. This leads to the prosecution and defense of professionals before governing bodies where the stakes are again immense for the professional and for the public. Thus, there is a substantial body of jurisprudence reviewing the decisions of these tribunals and aimed at ensuring an appropriate balance of fairness when weighing the competing interests of a professional and the public he or she serves. The legal uncertainty of professional liability cases, the adverse effects of public trials, and the time and expense of such trials have led to the recent attraction of ADR, and particularly mediation, as a preferred dispute resolution vehicle for many of these cases. The private nature of mediation and its relatively swift results can minimize the injury to reputation for the professional and the feelings of a second victimization felt by many plaintiffs in pursuit. Problem-solving discussions entailed in such interventions can highlight not only the complexity, the appropriateness, and the uncertainty of the dispute, but also those solutions needed and available to permit a quick resolution of the litigation. Difficult aspects of professional liability settlement talks which you will recognize include: 1, the cases are usually very complex and require a strong understanding of the technical and factual context. 2, because of 1, early settlement talks are often challenged by informational deficiencies. 3, professionals subject to litigation breed expert witnesses, and the divergence in expert testimony can be startling and further reinforcing of an impasse. 4, elite professionals are, in hindsight, attractive targets with their liability insurance and sometimes holier-than-thou reputations. 5, professionals can be less pragmatic in settlement talks because of potential injury to their reputations and licensure, because of the belief that they were right as always, and because of an institutional unwillingness to give in to factor 4, i.e. being an attractive target because of liability insurance, and doctors and the CMPA are a good example of this last phenomenon. 6, those suing professionals feel exploited because of their ex-ante reliance on these experts, and this feeling can ex post pervade their thinking in the form of a premise that but for the professional, no harm would have happened. 7, professional liability cases are often multi-party litigation, resulting in many subsets of negotiations as parties form tentative coalitions, but with major differences within coalitions of appropriate splits in any ensuing payout. The construction cases are classic. 8, professional liability cases are usually big dollar cases where the parties can afford and have the incentive to go the distance and roll the dice on a trial. And finally, 9, nevertheless, prospective cost, delay, complexity, appeals, adverse publicity, and the availability of insurance money in appropriate circumstances still constitute important drivers of settlement talks in these cases. These cases do settle. A quick look at your agenda today indicates all these issues and more are awaiting your review. Professionals are in many ways very important problem-solving glue in our society. Unlimited liability can therefore dry up or at least adversely change this vital support to our economic and social welfare institutions. On the other hand, a lack of professional accountability can have drastic effects on vulnerable clients and on society's need for social and economic stability. I suspect that an appropriate balance of these key interests will pervade everything you discuss today, as well as shape future legal outcomes. But on this point of problem solving, let me conclude with a short story about Charlie Steinmetz. Charlie Steinmetz is not a household name. However, in the field of scientific research and technology, the name is significant. Steinmetz built the electrical generators for Henry Ford's first plant at Dearborn, Michigan. One day those generators failed to function and the production at the plant came to a halt. Ford's mechanics and electricians were summoned to assess the problem. Unfortunately, they were unable to get the generators going, and Henry Ford was fast losing money. Desperate to resume production, Ford called Steinmetz. The genius arrived looking like a modern-day Columbo and seemed to just tinker around. He would tinker with one part and then move to another. Ford's employees stood in disbelief at the incompetence of this disheveled interloper. After a few hours of tinkering, however, Steinmetz threw the main generator switch and instantly power was resumed. Returning home, Steinmetz forwarded a bill to Ford for $10,000. Although a very rich man, Ford considered the amount outrageous in those days and returned it to Steinmetz with the note, "Charlie, isn't this a little steep for a few hours of tinkering?" Steinmetz reworked the bill and sent it back to Ford. It read, $10 for tinkering, $9,990 for knowing where to tinker. Total, $10,000. Ford paid the bill. However, we do not know if Steinmetz was sued for the original loss in production or subsequent malfunction of his tinkering. Thank you.
I'm fortunate enough to chair the first panel. On my right, I have Earl Cherniak, and on my left, I have Mr. Justice Goudge. We are going to talk about the bases of liability and follow on the things that George Adams has talked about. It was interesting in preparing for this panel, listening to both of my colleagues with their particular points of view and strongly held beliefs in certain areas, discuss where we are and where we're going. And I thought it might be helpful if I asked Earl to just start off by talking about a couple of his recent experiences and his views about the development of professional liability, particularly with a view to where the concept of fiduciaries is going.
Well, I'm going to start off by making a plea. And it's really one that's based on what I see as a failure of the courts, sometimes at the lower level, sometimes at the highest levels, to be rigorous in the separation of the fiduciary, the truly fiduciary from the non-fiduciary, not only in determining who is a fiduciary, but what is a fiduciary breach. Madam Justice Southern, in 1987, Justice of the British Columbia Court of Appeal, complained in the Girardet case that the word fiduciary is flung around as if it applied to all manner of breaches of duties by solicitors, directors, and others, when what really occurred was a breach of common law, contractual, or statutory duty. She complained that calling such activities a fiduciary breach carried with it what she, with her characteristic bluntness, phrased as the stench of dishonesty, along with the potential for a wider restitutionary remedy. In Black Minerals, Justice Zesapinka quoted Madam Justice Southern in the passage that I referred to with approval in his majority judgment, holding that arm's length negotiating parties could not be in a fiduciary relationship, and breaches such as the duty of confidence that was found by the majority to have been breached in that case, that would be breaches of a fiduciary relationship if it existed, cannot themselves be used to found the existence of a fiduciary duty. That's a distinction that is very often ignored, even 10 years later. In Hodgkinson, the Supreme Court of Canada, by a bare majority again, held that a professional advisor who did not make the final investment decision for his sophisticated investor client was nonetheless subject to a fiduciary duty and liable to restitutionary damages when he made a secret profit, even though there was no negligence at all in his advice. The point was that vulnerability was the test. It was not the test for Justice LaFerre in the majority. The reasonable expectations of the client was. Now, if one analyzes those cases and other cases like Norberg and Weinrib and other cases in the Supreme Court of Canada, the cases in which the court seems to find fiduciary duties are really those that amount to cases of disloyalty. But nonetheless, the fiduciary allegation still seems to be flung around with the same abandon that Madam Justice Southern complained of. Now, this debate has been recently resurrected by a what some might think when you read it, and I think Justice Goudge is going to comment on it, a somewhat intemperate judgment by Chief Justice McEachern in the British Columbia Court of Appeal. Seems to be a hotbed of fiduciary activity out there. And of course, Chief Justice McEachern was reversed in the Hodgkinson case, something that he's never forgotten. he accused the Supreme Court of Canada of failing to provide, there's a case called CA versus Critchley, recently, I don't think it's been reported yet, decided in November. He accused the Supreme Court of Canada of not providing sufficient guidance to determine whether a given situation is governed by the usual laws of contract, negligence, or other torts, or by fiduciary obligation, whose limits, he said, are often difficult to discern based on the decided cases. And the result has been, according to him, and I think, in fact, among other confusions, solicitors pleading fiduciary duties in the alternative in virtually every case certainly against every professional. Chief Justice McGarva went on to complain that, especially in lower court cases, the existence or no existence of a fiduciary duty seems to depend upon the level of outrage of the judge. And since, as he pointed out, different judges have different levels of outrage, as we all know, he thought that was a poor alternative to proper legal analysis. Now, it seems to me self-evident that even in cases which we're concerned with here, professional advisory cases, where there is often a fiduciary aspect to the relationship, that not every aspect of the relationship, and certainly not every breach, is a fiduciary one. A solicitor or a doctor or an accountant may be negligent and breach the contractual duty to be reasonably competent, or she may abuse a trust and make a secret profit and be disloyal. Such conduct and the consequences that flow from it ought to be treated differently, not the same. And apart from other matters, the application of doctrines like contributory negligence and whether conduct amounts to a mere error in judgment, not amounting to negligence, can be affected. The result can be significantly affected by how the duty is characterized. What I'm saying is that calling a person or saying that a fiduciary owes an undivided duty of loyalty will inform the one kind of case, but will not necessarily inform the other. So even when the relationship is fiduciary in nature and the breach relates to that fiduciary aspect, that should still be the beginning, or at least no more than the middle, of the inquiry. My take is that there can't be an unlimited duty of loyalty simply because there is a fiduciary duty. Otherwise, every law firm and every accounting firm would have to see if any client might be unduly affected by arguing a particular view of the law before an appellate court or tax tribunal, to see whether it adversely affected another client. Partners owe fiduciary duties to each other, but certainly they ought to be allowed to pursue their own interests, even to the detriment of another partner outside the partnership relationship. It may not be politically wise in any of those cases to do so. You may lose those other clients. You may poison the partnership relationship. But what we're talking about is legal liability, not what is politically or from a marketing perspective wise. So my view is that one not only has to look at whether there is a fiduciary duty. In fact, one has to look at the scope of it. And the facts relied for the breach of a fiduciary duty to no more define the scope than it defines the duty. Now, the case of accountants is the most current example that's before the court. And in a case that I'm currently concerned with, the issue is whether the duty of an accounting firm to a tax client is one of undivided loyalty such that no engagement can ever be accepted that might adversely impact upon that client. That's what Justice Ground held in Teplitsky versus the KPMG, a case that's currently under appeal, and he granted an interim injunction in the absence of any evidence of any actual breach of confidence or intention to make any use of Mr. Teplitsky's confidential information. He held that it was disloyal of the firm to consider taking on such an engagement without the consent of the first client. One can argue that what is really at risk is the reasonable expectations of the client. Do those expectations, in fact, go beyond the duty of of confidence, the assurance that no breach of confidence will occur. And one can think of the implications for accounting firms and other professional firms if the duty is as wide as Mr. Justice Brown thought it was. In fact, in solicitor's case, it's clear from cases like McDonald and Martin and a recent case involving Davies Ward and Baker MacKenzie, that where appropriate steps are taken to maintain confidentiality and avoid the potential for conflict, a law firm may well not be disqualified for taking on or continuing with a case contrary to the interests of a former client. So what's needed, it seems to me, is the avoidance in these cases of a knee-jerk reaction where there's a potential for a fiduciary aspect to the relationship, and the application of critical analysis to the facts of the case to determine whether the duty exists, its nature, and its scope. At least as it applies to professionals, what's required is a principled approach that isolates the unfaithful from the negligent and limits the finding of unfaithfulness to true cases of disloyalty. Otherwise, we risk perpetuating the 1988 criticism of Canadian law by Chief Justice Mason that Chief Justice McEachern just resurrected in the Critchley case. All Canada is divided into three parts: those who owe fiduciary duties, those to whom fiduciary duties are owed, and judges who keep creating more fiduciary duties.
Thank you very much. Listening to your comments, I had to keep in mind the fact that you were the winning counsel on the Hodgkinson case. But I'm going to defer and ask Mr. Justice Goudge if he might comment.
When Earl and Milton and I were talking a little about the title for this topic, basis of liability for professionals, obviously there are a whole lot of aspects to that. The usual issues about breach of contract that the professional owes to the client, the vicarious liability that firms may owe because of the actions of juniors in the firm, the joint and several liability that partners have for the actions of each other vis-a-vis their clients. But I think the two areas that kind of struck us as the areas that have the greatest uncertainty and therefore the most potential for difficulty when you're either suing or defending are fiduciary obligations that Earl's talked a little about, and negligent misrepresentation, building into that the whole area of economic loss law that the Supreme Court of Canada is wrestling with. I thought what I'd do is comment a little on both, starting with fiduciary duty and picking up on what Earl said. It seems to me there is a significant need to focus on the distinction between when a fiduciary obligation exists and the stretch of that obligation. That is, when will there be a breach of the fiduciary duty even where there is a fiduciary acting? And I think that's the point Earl's tried to make. I thought I'd read you a little bit from Chief Justice McEachern's decision that Earl quoted from, only because as a junior judge in a subordinate court to the Supreme Court of Canada, I can sort of share vicariously in the pleasure he must have had writing this. This is a case from BC where the Children's Aid out there was sued for a fiduciary breach by individuals who had been abused while in their care. And so fiduciary obligation is a significant issue. What Chief Justice McEachern, who writes for himself but gets another to sign it, says about the law is both useful but also frames the debate. What he says about the Supreme Court of Canada is just great gossip, so let me read it for you. Our Supreme Court of Canada has led the way in the common law world in extending fiduciary responsibilities and remedies, but it has not provided as much guidance as it usually does in emerging areas of law. The law in this respect has been extended by our highest court not predictably or incrementally, but in quantum leaps, so that judges, lawyers, and citizens alike are often unable to know whether a given situation is governed by the usual laws of contract, negligent, or other torts, or by fiduciary obligations whose limits are difficult to discern. He goes on to describe the cases that they've written about fiduciary duty, and then says, in delivering its judgments in these cases, the Supreme Court has written hundreds of pages. Yet it is difficult to find a comprehensive statement of the law. In some cases, there are multiple sets of reasons. We have no way of knowing how the learned justices of the Supreme Court of Canada might view this case. History suggests that they may have a number of different views. Clearly, there seems to be a decided trend towards the view noticed by Mason CJA, especially in, that's the too many fiduciaries in Canada, especially in cases of high indignation. But it is time, in my view, for the law to be made more certain and less subjective. Certainly, I regard it as part of this court's responsibility to urge the Supreme Court of Canada to clarify the law as best it can. I'd love to be able to write something like that. But he then goes on to frame the debate. And I think, viewed seriously, he sets out one side of this issue about how far fiduciary breaches go. He says, I conclude that it would be a principled approach to confine recovery based on fiduciary duties to cases of the kind where, in addition to other usual requirements such as vulnerability and the exercise of a discretion, the defendant personally takes advantage of a relationship of trust or confidence for his or her direct or indirect personal advantage. That's a very narrow framing of when there will be a breach of a fiduciary obligation. It has to do with taking personal advantage of the relationship you have as a fiduciary. Even within this judgment, there's a contrast, there's a bookend to that. Madam Justice Ryan doesn't agree with that phrasing, and her framing of the fiduciary duty stretch is this. She says, it follows from this explanation of the law that a breach of the duty will occur when the risk inherent in the relationship materializes. That is, when the fiduciary exercises the power entrusted to him or her to the detriment of the beneficiary or for the benefit of someone other than the beneficiary. Okay, so there's the tension. Is the focus on what the fiduciary gets for him or herself when the duty is breached, or is the focus on the detriment to the beneficiary from the actions of the fiduciary that are less than in the interests of the beneficiary? So within this case, you get the kind of bookends of the debate, and it's really unclear. So I think that's a very, very important issue for all of us to focus on, and frankly for the Supreme Court to try to pronounce on. They have spent a great deal of time focusing on the indicators that have to be in place before you call a relationship a fiduciary. It's, I think, a second level question, what Earl referred to as the middle part of the analysis, to determine just how far the duty goes once the label's in place. And this judgment, I think, sets out about as well as you can what those ranges might possibly be. And I think it depends a lot on which end of the telescope you're looking through. I mean, is the fiduciary obligation important because of what it says when the fiduciary breaches it? That is, the allegation of dishonesty and untrustworthiness that Earl talked about. That would tend to have you say, well, there's a breach only where the fiduciary has reaped an advantage in breaching the obligation. Or on the other hand, is the focus looking at it from the other end of the telescope, namely, what is the detriment to the beneficiary, after all, for whom the fiduciary obligation is put in place? And if the beneficiary fails to be benefited in a maximum way, then there is a breach. So without answering the question, I simply want to pose it, and I think this case does it about as well as any. Let me just say a few words moving totally away from fiduciary duty to negligent misrepresentation, because that's a much more traditional source of liability for professionals. It too has its uncertainties. As you all know, the Hercules case is a very good example. It engages the law of negligent misrepresentation, and within that, the whole sweep of the law in that area that the Supreme Court's tried to grapple with. You will all know that the Gans test has been now firmly embedded in Canadian jurisprudence. The two-part test that talks about the nature of the relationship between the representor and the person receiving the representee, and whether there's sufficient proximity to justify recovery, and the second step, whether there are any policy reasons that should limit the recovery to avoid the Cardozo complaint that not to do so would produce indeterminate liability to an indeterminate class for an indeterminate period of time. all that's very fuzzy, particularly when you get into the second step of the ANS test. That is, what sorts of policy reasons are going to be in play to limit liability. The court's been very limited in its jurisprudence on that. I suspect you'll hear more about it today. Suffice it to say that the Hercules case has left us with the proposition that where you have an opinion prepared by auditors for the governance of the company that is then used by investors for their own investment, that is using the opinion for a purpose other than the one it was prepared for, and that's a good policy reason to say no liability, even though there's enough of a close relationship between the maker of the opinion and the shareholder user of the opinion. So there's an example of where the second step of the ANS case, that is the policy reasoning, cuts in to shut off liability. There is a lot of discussion in that case, as there has been in one or two other cases, about the reason for the generation of the representation in the first place and the class of users that could be foreseen, and whether that serves as a way of trying to determine whether there's a sufficient policy stretch to say liability should be limited. But it is a really uncertain area, and so it seems to me that there too we're going to have to get some guidance from the Supreme Court of Canada. Until we do, all of us will be left reiterating the plea of Chief Justice McEachern, although perhaps in somewhat more muted language, that we'd like to see more clarity in both areas of the law. Let me stop there. No.
I'm going to confess to sitting on the other side of the fence. I take the view that I like these cases. I advocate the more expansive view of the fiduciary relationship, and I confess to not having a problem with the fact that the Supreme Court doesn't want to define what that duty, what the relationship is and what the duty is. I always think to myself that fiduciary relationships are a lot like mercury. You can put it on the table, but you can never get your hands around it. And, you know, Earl, I hear you say that there can't be an unlimited duty of loyalty. Why? Isn't it a question of what the expectation is?
Well, yeah, the question is, what is the expectation? If you trust someone with your confidence, how far does your expectation go? You trust that person to keep that confidence, but simply giving a person the confidence should not prevent that person, absent any breach of the confidence, from acting in a way that is contrary to your interests, and therefore could be considered to be disloyal, simply because that person has your confidence, knows something about you that's confidential, if it's clear that there is no breach of the expectation that you had in the first place. That's the way I look at it.
Well, let me just raise a hypothetical that we did discuss last week. And, you know, what if someone goes and hires a law firm that has, say, for example, a Toronto office and an Ottawa office, and the Ottawa office is retained for the purpose of representing you in a tax case. And in order to fight that tax case, you've got to make full disclosure of all of your financial circumstances. You've just got to bear your finances and your history of your financial dealings to the bone, and that law firm represents you in that proceeding. Can the Toronto office then come along a couple of years later and represent your spouse in matrimonial proceedings, even though the lawyers in Ottawa know everything there is to know about you? What would you say of that?
Well, I think probably the answer in that situation would be no, but I'm not at all sure that the basis for the no answer would be the fiduciary nature of the relationship. What you're positing there is a conflict of interest that is incapable of being cured because the courts have held, and I think this is a policy decision because it's not necessarily based upon fact or reality, that the knowledge of one partner about the affairs of a client is the knowledge of every other partner. Now, and as a matter of fact, in many, many cases, and maybe in the situation between Ottawa and Toronto, and almost certainly between Vancouver and Toronto, when we get into the multi-provincial firms, it may not be the case because, as a matter of fact, firms don't get together. The lawyers in the firms don't get together all that often. But once you, as a matter of policy, the courts say that any member of a firm's knowledge is the knowledge of another member of the firm, then one can't act on the basis of the conflict of interest that arises, and not simply because of the fiduciary nature of the relationship. Now, conversely, you've got cases like the Davies Ward and Beck case, where Davies Ward, one of its lawyers, acts as an expert witness for a defendant in a case, and that lawyer goes to the bench, and therefore neither that lawyer or Davies Ward is longer retained as the expert witness for the defendant, although there was some suggestion that maybe someone else in the firm would act as the expert, would be qualified to act as the expert witness. A lawyer then joined, Neil Finkelstein then joins Davies Ward, acting for the plaintiff in the case, and the defendant says, well, the plaintiff's lawyers now have to be removed from the case because the plaintiff's lawyers have joined the firm of this expert retained for the defense. And the motions court judge held that was so. Court of Appeal held no, that wasn't so, because they looked at the nature of the retainer of the expert witness, really a personal retainer as opposed to a firm retainer, although he was certainly billing on the basis of the firm, and they looked at the many institutional safeguards put into effect before Finkelstein joins Davies Ward, and are confident that no reasonable person would say there was any possibility of any transfer of confidential information, and said that, notwithstanding that the Davies Ward firm now carries a retainer to the interest, contrary to the interests of a former client of the firm, and therefore, in that sense, could be said to be disloyal to the firm. They were not disqualified. So, and it seems to me that case shows that it wasn't the undivided loyalty, the undivided question of loyalty that was the governing factor for the court, but rather it was a critical analysis of the reasonable expectations of the client and the nature of the original retainer. And indeed, it seems to me it's a reasonable expectations case, not a fiduciary duty case.
Well, do you think that it may be that all of these cases, whether it's that case or the Drabinski case, in the case of an accountant, or any of them, can be just looked at on the basis, what is the client or the person in the so-called vulnerable position, what is that reasonable expectation of that person? Can they expect that the person in whom they repose the trust and confidence, can they expect that person to stand up for them and at the very least to make sure they're never in a conflict. Do you want to perhaps comment, Justice Goudge?
Well, I have an easy answer to your Ottawa-Toronto example since I practiced at Gowlings in Toronto. Clearly, there's no difficulty acting, and we'll figure out a reason later. But I think when Earl says, you know, the Davies Ward case is a good example of this, I think that's right. I mean, if you define the fiduciary obligation as one of undivided loyalty, then there's no question Davies would be hoofed off the case just because the client would be able to say, Davies is my lawyer. They now cannot act against me. The court didn't do that. The court was a little more subtle than that, and they said, let's just figure out whether there is any risk in this to the client, whether the client can say, I don't like this disloyalty or not, because clearly the client would say in every case, I hired Davies to do an opinion for me. I don't want them acting against me. And the court said, no, that's not enough. Let's look at whether or not there is an actual risk to what the client was entitled to expect from this circumstance. And with the protections that were put in place, they found there wasn't, and hence no breach of duty. And it seems to me that at the risk of sort of sticking with my colleagues, that was a good decision. And I would hope that it displays the kind of subtlety that courts will increasingly have to engage in determining whether there is a fiduciary breach.
Well, what happens in this world that we live in, where you have, say, an accounting firm with accountants all over the world, 5,000 of them from here to Timbuktu? Is it a reasonable expectation, or is that something the courts are going to look at? Is it a reasonable expectation for someone hiring an accountant in Toronto to expect that nowhere in the world will they ever act contra his interest? Do you think that's where we're going?
Well, I guess if I was a member of one of the smaller accounting firms, or if I was a member of an accounting investigatory boutique, I'd say that's a wonderful decision, because that's the best. That'd be the best marketing tool that I could possibly have. So I guess it depends where you sit, whether you like it. It seems to me that given the way that the business of this world has chosen to use the accounting firms of the world, that kind of a standard is unrealistic. Let's take an example that I use in the argument in Davinsky, and that is the very common situation where an accounting firm doing an audit for a major client and doing a variety of other work, consulting work that accounting firms often do, as well does the personal tax returns of the senior executives, including the most senior executive of the client, and I think that's a common situation. In many cases, it's a very good idea, because the business wants to be sure that its senior executives have their income tax returns done in a certain way, so they'll never be embarrassed by an improperly done tax return. And then, in the course of the audit, the board of the company gets some information that there's an allegation that the senior executive is stealing from the company, and it naturally will look to its auditors and say, "We've got this information. Will you please make sure that your audit includes an investigation to determine whether these allegations are or are not so?" Now, there's no suggestion that the accounting firm will look to the records of the senior executive for that purpose, but what they will do is scrutinize the corporate records to determine whether there is anything to these allegations. And of course, it would not be in the interest of the corporation to advise the senior executive of that. That's a normal audit function. That's what would normally happen. Is the auditing firm to be precluded from conducting its audit in that way, because it would say, gee, you know, we've done some work, we actually do some income tax return for them, you'll have to hire another firm to do this audit. I mean, seems to me an unrealistic way to carry on business, but it seems that might flow from what might otherwise be described as an undivided duty of loyalty.
Does it change it, Earl, at all if you change the hypothetical and say this is a sole practitioner accountant? Forget the big firm that can have Chinese walls. You've got a sole practitioner accountant who is doing Mr. Drabinsky's tax return and also Livant's audit. Is Mr. Drabinsky the least bit entitled to say, I don't want the person who has done my tax returns for 20 years doing an investigation for Livant that may impugn me? They are bound. You know, that is bound to result in information that was obtained in one fiduciary relationship being used in another.
No, I mean, I think that's right, because I think the answer is you couldn't do it in that situation, and the reason that you can't do it is because it would be impossible to undertake that task without making use of, consciously or unconsciously, the confidential information that you have about the individual's tax affairs. So it would be impossible to avoid the conflict. Whereas in the case, in the example I gave, it would be both possible to do it, to avoid any possibility of conflict, and incumbent on the firm to do it. And you know, and the danger would be that it being done out of the same office and people sharing the same coffee room or the like, that it couldn't be done very well. And if it's not done very well, then the client's got a perfect right to complain.
But that does suggest that the debate is between the individual client's right to say, without limit, you owe me a duty of loyalty, and a more sophisticated look at whether, when the fiduciary does something else, there's actually risk to the person who complains, to the client who complains.
Yeah, but it also requires, if my example holds, and I guess we'll see ultimately whether it does, it also requires an analysis of what the scope of the duty is,
right,
and not merely the existence of the duty.
What about the fact that in the case of a lawyer, you can simply bring a motion to have the lawyer removed as solicitor of record, and there's lots of those motions before the court. In the case of a chartered accountant, there is no mechanism to have someone removed as accountant of record, so you proceed, presumably, which is what they did in the Drabinsky case, they proceed by way of interlocutory injunction. And then what we have in that case is there is no irreparable harm, yet the injunction was granted. Do you think that it makes any difference as to which profession it is where that conflict is raised?
You know, with lawyers, it's easier because the court controls its own process, and it controls who can represent clients and who can't. It doesn't control any other profession in the same way, and therefore the device of interlocutory injunction has to be used with the added gloss of ensuring that the application meets the standard necessary to allow interlocutory injunction. But in practice, I think the test, the way the court would look at it, would not be all that much different.
Do you agree with that?
I think that's probably right, with the one caveat that I think it depends a lot on getting some clarity to this double-barreled notion of when fiduciary obligations exist, and if they do, what their scope is. Because if the broad sort of untrammeled view is given in answering both those questions, then a court's instinct is going to be very aggressive in shutting down any further operation on the part of a fiduciary who is alleged to be in breach of the duty. There's a kind of visceral sense, if you don't get sophisticated in your thinking, that a fiduciary can't do anything that a beneficiary complains about. You know, with the caveat that I think a lot depends on getting clarity to those two notions, I think the court would approach various professions much the same way.
I wonder, we only have a few minutes left, and I thought I would raise a totally different point and then see if we can have some comment on that. In the Hodgkinson case, the trial judge had found that had the fact that the advisor, the professional advisor, was getting a commission or had an interest, a financial interest in the transaction, had that been disclosed to the plaintiff, he would not have done the deal. They go on to say, Laforêt in the majority judgment, maybe I should just pull it out, goes on to say when speaking about damages, and I'll just read this little note, the submission runs up against the long-standing equitable principle that where the plaintiff has made out a case of non-disclosure, referring to non-disclosure of a material fact, and the loss occasioned thereby is established, the onus is on the defendant to prove that the innocent victim would have suffered the same loss regardless of the breach. The point being, as soon as you show the non-disclosure of the material fact, then the onus shifts. What was interesting is that just before that, Chief Justice Dubin, in a case called Rasso and Dionigi, dealing with a real estate agent who had failed to disclose that his sister-in-law and brother were buying a property and that they had more money than they were prepared to spend. And the agent had failed to disclose that to the vendor, who was his client. In that case, Chief Justice Dubin said, a fiduciary who breaches his duty by non-disclosure of material facts is not entitled to prove that the transaction would have been concluded had disclosure been made. In other words, and he goes on to say, as soon as there is a non-disclosure of material fact, there is almost automatic liability. It becomes irrelevant, and if you read the rest of the case, he says, it becomes irrelevant to even ask the question, would the deal have been done anyhow? Now, the Rasso case seems to impose a very, very high standard on the fiduciary to make sure that all facts are disclosed, and if you don't, you're going to be liable. In Hodgkinson, I was of the view that since the issue wasn't on the table because of that admitted fact that the deal wouldn't have been done, that the court, even though it does reference the Rasso case, didn't analyze the point, and my own view is that it's obiter. But is there any way of reconciling those two cases?
Well, I think I'd have to study them a little more carefully. But in Hodgkinson, certainly, if there would have been a finding by the trial judge that it would have been irrelevant to Hodgkinson as to whether he would go into the deal if he knew of the interests that Sims had. I mean, I think that would have been fatal to the case. In the Court of Appeal, the British Columbia, the matter turned to some degree on the basis that what Hodgkinson lost was based on the drop in the economy and the fact that virtually every MERB in the province lost all its value. And Hodgkinson, if he hadn't taken this deal, would have taken another deal that was just as bad. But the Supreme Court of Canada was not prepared to make that leap. It was good enough for the Supreme Court of Canada that Hodgkinson said, and was believed by the trial judge, that he would not have gone into this deal. And since there was no evidence and no finding that he would have gone into some equally bad deal, the court fashioned, as did the trial judge, a restitutionary remedy, restitutionary damages, being the amount of his investment less the tax saving. Now, you know, whether that can or cannot be rationalized with Chief Justice Dubbin, I'm not sure.
Any comment on where that Rasso case stands in the spectrum?
This argument's been put to us before, and I've done my best to duck it. And
I've done my best to advocate
by
it.
our learned
I just did.
chair here. Putting it very persuasively in a case where fortunately we found a way out and didn't have to deal with it. I guess my sense, Milt, is that ultimately one would hope that the court would focus hard on whether or not there were damages in play, and that in the Hodgkinson case, if it had been demonstrated that the investor would have gone into an equally bad deal, that would be a significant consideration in determining whether damages should be awarded for the withholding of the information. There is, on the other hand, a significant tension produced by the finding of a fiduciary obligation and by this implicit notion that I think all three of us have been saying ought to be scrutinized with some more sophistication of how wide the duty goes when it exists. But given the momentum that comes from the existence of the duty and a relatively unsophisticated look at where the edges of the duty are, there is a pretty strong instinct in the court to provide virtually full coverage for whatever it is the beneficiary says has been lost as a breach of the duty. I would like to think that over time there will be growing sophistication to analyze that, just as I would hope there will be growing sophistication in analyzing where the outer boundaries of the duty are once it is labeled a fiduciary relationship.
Just on that point about if you didn't do this bad deal, you would have gone into an equally bad deal. I've heard at least one judge of the trial division describe that as saying, well, if I would have stepped off the curb and got hit by this car, I would have stepped off some other curb and got hit by another car, so why am I complaining about it and seeking damages? We may hear during the course of the day more about that, which some people in the room call the contingency defense. Anyhow, our time is just about up. We have a minute or two for questions if anyone has one, but I know that Justice Goudge has to be out of here in about 2 minutes.
Yeah, I'm afraid I do.
Can I ask, is the scope of the fiduciary duty limited, always limited by the scope of the retainer? How do they interact?
That's a very good question. I mean, putting the question another way, can the professional circumscribe the duty by a written retainer, for example? I mean, my instinctive sense is yes. But you'd get into all sorts of questions about unequal positioning when the retainer was written and so on. But a fiduciary obligation, I guess my basic thesis is just by labeling a relationship that of a fiduciary, one ought not to say there is an obligation that goes to the end of the universe. And whether one circumscribes that in terms of reasonable expectations or written retainer, that is reasonable expectations objectively viewed or written retainer, I don't know. But
It can certainly be circumscribed by disclosure. And if there is disclosure, matters that could be a breach of a fiduciary, let's assume that there is a fiduciary obligation. If there is disclosure and consent, it seems to me that that the scope of the duty can be circumscribed in that way. If you know, it seems to me that you can limit it by retainer, but most of these relationships are not in writing and therefore often treated by the courts as very broad.
There's a court that's sitting at 10:30, and I know Justice Goudge has to go. We're going to break for coffee. I'd like to thank both of my colleagues for taking time out of their schedules.
thank you.